Doug Benefield was a 54-year-old single man. He became a widower for 9 months when he met a 24-year-old woman. Her name, Ashley Byers, a swimsuit model and ballerina. The romance moved quickly, very quickly, and within 13 days, they were married. They lived in Charleston, South Carolina. Doug was a successful consultant working in technologies and with the government. But Ashley had a dream of opening a ballet company in Charleston. Doug supported that effort, and together they started to put it together. But in the midst of it, Ashley got pregnant. From there, the relationship went south, and Ashley also went south to Florida to live with her mother. The couple became entwined in a bitter custody battle for that baby. Ashley accused Doug of trying to poison her, something the family court judge did not believe. Then, just before a big court date, Ashley shot and killed Doug. She's been charged with murder but is claiming self-defense. And now, as she prepares for her trial here on Court TV, we are live from Manatee County with all the latest in the Black Swan murder trial. I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments. And we've got another big trial getting ready for you right here on your front row seat to justice. And all this coming off of the 3 months that we spent covering Karen Reed. And big part of that story, that case, was the sea of pink that was flowing throughout Dedham, Massachusetts, and Canton, Massachusetts, the people who were supporting the accused murderer in that case, Karen Reed. Well, we know at the end of the day, the jury was deadlocked. Some controversy connected to the deliberations of the jury. But it was those supporters that made that story different. And while all that was going on, there's another story happening down in Florida, down in Manatee County, Florida, where another woman is accused of murder. And now she has supporters, and I'm wondering if this is going to turn into an ocean of purple to support a woman named Ashley Benefield, who's charged with shooting and killing her estranged husband, the father of her child, Doug Benefield. So there are some similarities in what I'm seeing here. I don't know if it'll manifest itself the same way, because in the Karen Reed case, I mean, it took years for that thing to build up, and it reached its peak at trial. This seems to have just started to take form. And I'm wondering if they were watching what was taking place up in Massachusetts and saying, hey, this might be a way to garner some support for Ashley Benefield, who is facing, a lot of time behind bars for shooting and killing her estranged husband. She's claiming self-defense in all this. Now, another similarity to the Karen Reed case is that Ashley Benefield is out on bond. So you will see her walking in and out of the courtroom. She's not going to be locked up during the course of the trial. She'll be able to come in and out. And she's been doing this for a couple of years now. So that will be another dynamic during the course of this trial, as you will see her and her defense team, how they're reacting and how the supporters are reacting with her as well. Could be a very tense situation at that courthouse. It usually is a little more tense when the defendant is out on bond. Now, this whole thing starts on Monday, right here on Court TV. Obviously, we will be covering it. And right now, though, I want to go to Court TV producer Cody Thomas, who's on the case tonight, joining us live outside the courthouse down in Manatee County. Cody, I want you, you're down there, you're on the ground. I know it's warm, I know it's hot. But what was going on outside of court today? Because there was a hearing today. Was there some level of support for Ashley Benefield?
Well, Vinny, there was definitely a level of support. It was a little quiet at first. I got here maybe 30 minutes before the hearing started, but around 8:30, maybe 6, 7, 8 members of that newly formed support group called We Stand With Ashley showed up, just expressing their support for Ashley on the courthouse steps. They were waving at traffic coming by. But the interesting thing about that group is that Ashley's own mother was a part of that group, as well as her 6-year-old daughter that she shared with Doug Benefield was part of that group. And, you know, I talked to them. They didn't really want to speak with us on camera, but as I was conversing with them before I went inside that courthouse, all of the members were kind of echoing the same idea of that it should not be a crime to defend yourself. And as you said before, we know Ashley Benefield is claiming self-defense in this case. She tried to use the stand your ground law. That was ultimately denied last summer down here in Florida. But one more interesting thing about this group is that they had it was very evangelical. They had a big prayer circle before some of them went inside. So I assume that they're going to be out here at the crack of dawn on Monday and the days following as the trial continues.
A couple things a little unusual about this. So you've got the little girl, and we're looking at her right now. The victim is her father.
That's right.
The defendant is her mother. And she is now holding signs out. I've never seen that before. Never, ever. Usually in these cases, the children are sort of hidden away from view. Interesting development in the way they are approaching all this. Let me ask you, Cody, though, about, they don't want to speak, though. We invited them on the show tonight and to get their perspective, their point of view. But they didn't want to speak, and they didn't want to speak to you either on camera?
They did not. They told me a general consensus that they were choosing not to speak to the media, despite me saying, you know, we'd love to get their story out there, hear their side of it. But they were pretty steadfast in the fact that they wanted to keep their mouths shut for now. They especially didn't want the little 6-year-old daughter to say anything to us. So not even all of them went inside the courtroom. Only about 3 or 4 of them went in there. And, you know, we conversed a little bit as I was sitting in the pews. But ultimately, they were keeping their mouths shut as far as media coverage goes.
Well, that's a little different than what was happening in Massachusetts. Everybody wanted to talk. Everybody.
Right.
And they did. And they absolutely did.
Right.
So that's a little bit different. Let's talk about Ashley Benefield. She was in court today because she hasn't been there for all of the pretrial hearings, but she was there today.
She was there today. She came in very quietly, very stoic, actually. She didn't really say much of anything throughout that entire 5-hour hearing. You know, only talking when addressed directly by the judge during the colloquy when he was kind of explaining, you know, this is what you're facing, which is, you know, 25 years to life. And even then, she was just saying, you know, yes, Your Honor, no, Your Honor, even saying, I believe so, Your Honor, as if she wasn't sure in her answers, and even deferring some of that answering to her attorney to answer for her when she was speaking. But one thing that was interesting, when she was somewhat conversant, she was talking to that paralegal sitting to her right, Jack O'Keefe, who is now, as we know, after the ruling today, is not allowed to sit at that defense counsel table. He's allowed to sit in the pew right behind the defense table. But when she talked, it was only to him. I couldn't really hear what she was saying. It was all very low. But that's the only person she was really talking to during this hearing today.
And so the supporters, was there any sort of interaction with the support? No, but the Karen Reed, obviously there's a lot more supporters, but it became like a thing where she's entering the courtroom and she's coming in, and there's a, did that moment happen with Ashley Benefield today? Anything like that?
Not necessarily cheering outside as she walked in, but it's interesting you bring that up because as we were sitting there, one of the bailiffs in the courtroom came over to one of the supporters who was maybe 3 or 4 seats down from me and told her that she couldn't keep having these emotional reactions. They weren't super loud, but you know, when something didn't go the way that I feel that she wanted it to go, she'd throw her hands up, you hear a big sigh, you know, on some of the judges' rulings. So there's definitely support there, and there's definitely strong feelings of compassion for Ashley among that new support group that's only been around for about 2 months now.
Okay, how about after the hearing? What happened today?
Her and her attorney left very quietly, very peacefully, and I tried to catch up with the attorney to get a quick post-trial or post-hearing statement. Here's what he had to say.
Hi, Mom.
Feel prepared after the hearing today for trial? How do you think the decision that O'Keefe won't be at the table will impact the trial? So as you saw right there, not much of anything to say at all, but I'm sure once 8:30 a.m. on Monday hits, that energy will definitely shift in a different direction.
All right. Cody Thomas in the middle of it all, where it's getting ready to begin down in Florida for us this week. Cody, thanks so much. Appreciate it. We'll be talking to him throughout the week on this case and other cases that we are investigating here. Now, the hearing today. Let's show you exactly what happened inside the courtroom today.
I'm so confused right now.
Okay.
Do you mean you think, hold on, let me be sure. Are you saying that I just took the time to make all these rulings on the disputed redactions, and you think the state would try and introduce an audio recording that had in it the things I just excluded?
No, I want to just make sure, though, that that's the case, that they are going, if they choose to play the tape rather than the defense, that they will redact it accordingly.
If they didn't, I would lose my mind. We're less than a week from trial, and I am so confused. Is this a battered spouse syndrome case or not?
The courts prohibited the state from using Judge Moreland's pronouncement. So they have pivoted, and now what they're going to do is they're going to say that failure to receive satisfaction from any of these child abuse allegations created the motivation for Ms. Benefield to shoot Douglas Benefield.
If my rulings before haven't been clear, at least implicitly clear, this is a homicide trial, a murder trial. I'm trying to avoid having a family law, domestic relations, divorce, child custody, child time sharing trial within this murder trial. And I've tried to give latitude to both sides to follow their theories and present their defenses and their arguments on the state side. But the nets that both sides are casting are just getting a little bit too wide. I'm going to grant the defense's motion in limine to prevent Ms. Griffin from testifying. Do you swear firm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, and the microphone's kind of close to you. Just make sure you speak in a loud, clear voice so it picks everything up. Do you understand the charge against you, ma'am?
Yes.
Are you presently suffering from any mental health issues?
No, Your Honor.
Have you been treated in the past for any mental health issues?
I think the facts of this case establish that pretty clearly.
These are competency questions. I'm not going to start going into detail. I just want to make sure that she's competent to make a.
I can assure the court Ms. Benefield is competent.
I'm sure you understand that if you are convicted of this offense as charged, the court would have no discretion but to sentence you to a minimum mandatory of 25 years, and it could be up to life.
I'm sorry, Your Honor. This was covered previously, and I think to go back over it again now is intimidating to my client.
Oh, I'm certainly not intending that at all. All right, ma'am, so you've had a chance to discuss the case with your attorney. Have you reviewed all the discovery that we talked about? Is there anything that's surprising that you haven't heard about? Have you reviewed everything that you have, Mr. Taylor, with her?
I can tell the court we have kept our client advised as to all of the evidence and discussed the case with her.
Perfect.
I'm a little concerned some of these questions are intruding on the attorney-client relationship.
If you object to them, that's just fine. My intent is to make sure that the defendant is freely, intelligently, voluntarily taking this case to trial.
I have thoroughly prepared my client for trial in this matter. She has no outstanding objections to that preparation. She is well aware of her exposure, and she has confidence in who she has selected to represent her, and we're ready to go.
A lot at stake in this case, a lot. I want to bring in a special guest joining us, Doug Benefield's cousin and family spokesperson, Tommy Benefield, with us. Tommy, nice to see you. This thing is starting up on Monday. It's been a long road. Are you ready? Will you be testifying?
Yes, sir. Just so people know, it's 1,395 days since Ashley killed Doug. Regardless of what the answer in the trial is, that's how long this has been. Our family's ready. We'll have family in a much bigger strength than the We Stand With Ashley group that was there last week or today. We're ready for the trial. I am on the witness list, potentially for more than one portion of the trial based on whatever the opening statement of the defense is. Well, that's for Suzanne O'Donnell and her team to decide who comes up. I certainly will be on the first day as a witness.
What are your thoughts about what we have been seeing outside of the courthouse now? The folks in purple, including Doug's daughter, being outside with a sign.
We fully understand them supporting her. That's their right. That's their First Amendment right. In many, many places, it's not legal to have the child out there, especially a 6-year-old. And while she didn't say anything today, they did last Wednesday. ABC 7 did speak with the daughter, and that was part of interviews last week. So they've changed what they're doing. But to us, this is child abuse, just like Ashley has child abused their daughter before. The daughter was 2.5 the night of the killing, and now she's 6. We're not sure she even knows that she had a father except for this stuff.
What are your thoughts about what the defense is going to be here? They're talking about self-defense, obviously, but also battered spouse syndrome.
Well, we're very comfortable with the presentation of evidence in this case. The evidence all stands against her being a self-defense case, and especially in the battered spouse syndrome, if that's what they decide to do. Battered spouse syndrome, I know you're going to have experts on it later, requires 3 things. We've investigated it. Self-isolation, she never did that. Suicide thoughts, we're not aware of any of those. And substance abuse, we're not aware of any of those. And it's clear that the other part of this is the words are Doug would have had to coerce her into a bunch of activities that she was against her will. And that's clearly not who she was through their relationship. So we're comfortable that if they bring that in, or they bring in the other thing that came out the last 2 weeks about a quote unquote cardboard box attack. Once again, you saw the one little mark on her body that was previous to that night. She had no marks on her body 4 nights later. We're comfortable, no DNA on her from him. The evidence, that's the one you're showing there. That was from a previous event. And she didn't have any marks on her the night of the 4 nights later. And we're comfortable that that's not what happened.
Tommy, when you mentioned the abuse of the child, you're not talking about physical abuse of the child. Can you explain what you mean?
Sir.
Because there's no evidence of physical abuse of this child anywhere. There's no charges or anything.
No, I'm talking about 25 hyperbaric chamber appointments 3 months after the child was born, pretending that the child and she had been poisoned, which was disproved every bit of the way through this entire trial, and all the investigations disproved that. But yet Ashley put the child through 25 hyperbaric chamber, which it doesn't even have the capability of doing that for a 3-month-old. And then putting that child out there in front of the courthouse with her sign. We understand the sentiment, but that's not what most people do. That's very unusual to do that with a 6-year-old child.
And you also mentioned that there's going to be folks from your family down there. How big of a crowd of support is going to be there, and what do you expect the scene to be like at the courthouse?
Well, we have 10 to 15 people that'll be there on any given day. They're all family members, and several of us are going to be on the witness list for the prosecution, and obviously against her. Last time when we had the hearings for the stand your ground that she lost, and the appeal that she lost, that actually lost on both cases, we were there. There's no contact between the two groups. We're going to be very calm, as we've been calm all the way through this, to wait for justice to be meted out.
What's been the most frustrating part of this whole ordeal from the beginning? Because I'm always interested in hearing from families that have gone through the system of justice. And from your perspective, what's been the most frustrating part of this?
Well, before we say frustrating, I'd like to commend the judge, because he's been incredibly giving and graceful to both sides for everything they presented, number one. Number two, the state's attorney's office, the victims advocate unit, have done a great job in Manatee County because this is a big trial. But the only frustration for us is this can boil down to a very simple case of on Friday before she killed Doug, she knew that there was a chance that Judge Moreland was going to give custody of the child to Doug the following Wednesday after she killed him. It's very, very clear by her sending her mother and the child out after Doug's packed all the U-Haul out except for one box and a mattress, and those pictures will come in. It's really that simple a case. There's a lot of muddying of the water of all the other things that happened leading up to this, but they had reconciled the week before, had told the judge they wanted to get back together. They were dropping the divorce case, and it doesn't seem like that's what someone would do willfully if they believe that they shouldn't be with that other person.
Tommy Benefield, appreciate you coming on tonight, and obviously we'll be speaking to you throughout our coverage of this story. Thanks so much.
Thanks, Vinny. Thanks for y'all's interest in this.
When we come back, folks, we'll bring in our think tank, get some analysis on what the defense may be in this case, plus coming up next hour. OnlyFans model Courtney Clenny says she threw the knife at her boyfriend Christian Obumseli in self-defense. She's charged with murder, and tonight we'll figure out if her story makes any sense.
Did a customs agent commit cold-blooded murder?
Marsha Thompson is accused of fatally shooting her husband as he's lying on a couch.
She's claiming self-defense, alleging that Terry Thompson repeatedly threatened to kill her.
So what really happened inside this home?
Now a jury will decide the fate of this law enforcement officer.
And Court TV will bring it all to you.
The Abused Wife or Murderer Trial, weekday mornings, only on Court TV.
Battered spouse syndrome, as announced by the state Supreme Court, is the umbrella. Underneath battered spouse is abusive behavior. The distinction, subtle as it might be, Judge White, is that most of the time in battered spouse syndrome cases precisely, the victim still resides with the perpetrator, and they are subjected to repeated physical beatings. Domestic violence and abuse is a little broader, but it is the same factors, and it carries the same psychological issues for the victim.
So in this case, Ashley Benefield's defense is a little vague right now. To me, it's not crystal clear, and I think part of what was going on in court today was the judge trying to get some clarity from the defense on what the defense is. Now, they did file a notice of intent to rely upon battered spouse syndrome. Take a look. So Ms. Benefield intends to rely on the defense of battered spouse syndrome, domestic violence, and abuse. Ms. Benefield expects to prove that she was the victim of domestic violence and abuse perpetrated by the deceased Douglas Benefield from 2016 to 2020. And those are the years in which they were married. Let's take a listen now. This is from the 2018 injunction hearing. This is when they're in the midst of this battle. You're going to hear from Ashley Benefield, and then you're going to hear from Doug Benefield on some of the allegations here, including Doug Benefield firing a gun into the ceiling. Take a listen.
He was standing in the opening of the closet, and I was standing right on the outside of the closet, and he turned around and he punched a hole through the wall with his fist. He pulled the gun out. I believe it was in his boot, and he pulled it out and he started waving it around. It was unholstered at the time. He then threw the gun facing me. It missed me. It hit the wall behind me, and it punched a large hole. He started screaming, and he told me that, this is a quote, that he was going to blow his brains out. And so I stopped, and I dropped to the floor, and I started crying, and I begged him to not shoot the gun. And he said that I was going to have to watch him shoot his brains out. And I was screaming and asking him not to. I told him I wouldn't leave. I was literally on my hands and knees. And he, I guess at some point, discharged the gun. I didn't see him aim it at the ceiling, but the bullet went into the ceiling.
In 2017, you shot a gun into the ceiling of the home with Ashley present in the same room, correct?
Yes, sir.
She started to have a nervous breakdown?
I mean, I don't know what the definition of a nervous breakdown is. I just knew that I was under enormous stress and we needed to pause for a minute. There's not a lot of great ways to figure out what I was thinking. It was definitely to put a stop to the conversation. I've never hurt anybody in my life, but it was definitely it was right there in front of me, and I'm a country boy, I grew up with guns, and so I just shot into the ceiling.
All right, so he's admitting shooting the gun into the ceiling. So obviously there's things going on in this relationship, right? Well, they ended it, but there's problems there. But how does all that relate to where we are at this murder trial? Let's bring in our think tank. Joining us tonight, trial attorney, former police lieutenant Rick King. Also joining us, trial attorney, fellow of the American College of Trial Lawyers, Ann Bremner. And finally, criminal defense attorney, former federal prosecutor, Michael Sterling. Welcome to you all. Rick, I'll begin with you. You're in Florida. You're the Florida guy.
The top spot.
Yeah, and you're up at the top spot, so you got to go first. Where are we in this relationship between claiming, well, there was a stand your ground immunity type hearing, right, that she lost. There's self-defense, but then there's this battered spouse syndrome and domestic violence and abuse, and at the time they're estranged. So how does this play all together? Does it make sense to you?
So it does, in the sense that, so first of all, just know that because they argued the stand your ground hearing and she lost it in that hearing, she gets to argue it again at trial. So that's not gone away. Where we are in this mixed defense of stand your ground and battered spouse syndrome is, so typically in a battered spouse syndrome, you know, the people reside together, and it's a retaliation, and unlike stand your ground or a regular self-defense claim, in a battered spouse claim, sometimes the force by the victim in that case doesn't come on the heels of what could be imminent danger. In the battered spouse, you're saying that this could have happened when she wasn't in that type of imminent danger, but because of the cyclical nature of the abuse or the violence, she felt compelled to use that force. It's convoluted, and it's a difficult hurdle to make, because sometimes the abuse might not be what you would categorize as always violent. Sometimes it's mental or emotional, and so it's a difficult way to prove. They've got a long way to go with a couple of injunctions. Although I will say that firing into the ceiling thing, I mean, for me, that's quite an intimidating thing to do to someone in a relationship like that. So I think they got a long way to go, but I understand how they're trying to put it together.
Ann Bremner, I look at the situation and what was going on at the moment, and I believe the allegations will be from the prosecution that they had agreed and informed the judge that there was going to be some level of reconciliation going on here. Like the U-Haul is at her house. And it seems she's saying all of this was a ruse, pretending that she was going to get back together with him so he wouldn't act out, and then she was going to be placed into a place of safety in some hotel in St. Petersburg. It's all very confusing to me, but the ultimate hearing never happened because of the shooting. So what are your thoughts about how all of this plays with either battered spouse, self-defense, or some combination thereof?
Well, you know, remember what the judge said. I mean, the judge was basically in the pretrial hearing saying that this is just not credible, the stand your ground. What was the word? Like there isn't a scintilla of evidence?
That wasn't the stand your ground. That was in the in family court. Right. That was a family court, Justice. Right. That's not coming in front of this jury, by the way.
I know, but it's just kind of a pretty good indicator when the judge says, I don't believe any of this, what she has to say. I mean, in terms of one person judging her credibility or the credibility of this defense. I mean, it used to be called battered woman syndrome. And I remember my ex-husband had the first case in Washington State years ago. And it was a very tough defense of somebody that essentially defended themselves. And they used to call it battered women, not battered spouse, they do today. But basically that you're so fearful, given all of the abuse you've suffered, that you act accordingly. This is a tough case for her. I mean, and she's basically setting it up in a way that's pretty theatrical with her daughter out there and her mom and everything else. But I don't see this being Karen Reed Part 2 by any stretch. I mean, the fact that they're going to reconcile and just kind of convoluted explanation of why that wasn't the case, etc. And just one piece of evidence he shoots up in the ceiling and he explains it, I think, relatively well. I think it's a really tough case. And I just don't see a jury buying all this, that there was battered spouse syndrome, per se.
Michael Sterling, I want to add one more thing to the equation. This is from December 11th of 2019, Manatee County Sheriff's affidavit. My neighbor, Mary Ann Kropf, texted my mom that she had just confronted a man in the backyard. That was at approximately 8:30 p.m. After texts back and forth, we called her, and she expressed concerns that the man may have been my soon-to-be ex, Doug Benefield. This adds to my concerns that he's stalking me. I have come home to see Doug on foot in front of my house. Doug admits to following me to work, hiding in the parking lot, taking pictures and videos. Doug admits to putting a secret tracker on my car. So we've got all this stuff floating into the family court. Now here we are in a murder case. She's never given a statement on this. She gave no statement to police. She didn't testify in the Stand Your Ground hearing. So is she going to have to tell her story now at this trial, Michael?
Probably, Benny. If they want some of this to come into evidence, I believe she probably will have to tell her story. Because part of the reason that information like this comes in is it goes to the knowledge of the defendant, the knowledge the defendant had of the person that they had to defend themselves against. So if she wants to talk about, if the defense attorneys want to introduce evidence of Doug Benefield shooting his gun in the air, of these concerns she had of her fear, which leads to her reasonable fear on the day in question, if they want to talk about the knowledge she had, which will go to her intent and her fear, her reasonable fear goes to the reasonableness of her fear. If they want to have that conversation in front of the jury, they're probably going to have to call her, because that's the only way the information comes in. The only way the information comes in about his past conduct and things that she was aware of. Now, as long as she's aware of it, it can come into evidence. So if she can, at least that's my understanding, if she can, if she can point out, here are the things that I was aware of that led to my reasonable fear on the day in question, then she's gonna have to testify. She's gonna have to take the stand.
And there is an advantage, right, Rick? And we don't have any time for response, but I know you always talk about this. She has not spoken. She has not given a statement about what happened that night. So the first time we're gonna hear it will likely be during the trial. When we come back, the 911 call. We usually hear the whole call at trial. Not in this case. Coming up, I'm going to play for you what the jury won't hear.
So you were in an argument?
I don't know. She came in. She was quite hysterical. I didn't know who was banging on my door. Said that he attacked her, and she shot him. They've been having trouble.
That's part of the 911 call in this case. Now, the call is not made by Ashley Benefield. You can tell by the voice. It is her neighbor. She runs over to her neighbor's house. He makes the call, but in the background, you'll hear Ashley Benefield. Now, the jury's going to hear the 911 call. Prosecutors are going to play that for the jury, but they're not going to hear all of it. Parts of it have been redacted. So we have for you some of the pieces that the jury won't hear. I want to bring back in our think tank, Ann Bremner, Rick King, Michael Sterling. I've got some little pieces that are going to get cut out of this 911 call. Jury's not going to hear them, but I want you to hear them, and I want the folks at home to hear them as well. Let's take a listen to the first one.
We need the police before the mother, her mother, and the little girl gets back from the park. I don't want them to find this.
All right, Rick, jury's not going to hear that. Any particular reason?
I would imagine because it's inflammatory. It's about the little girl coming back, and probably would create an image in the jury's mind of the little girl. And I think that's not the focus of the case. Other than that, I can't think of any reason why they wouldn't be able to hear that.
Yeah. What's interesting, and though it brings up an interesting fact in the case, is that when this self-defense takes place, Grandma and the little girl are at the park.
Interesting.
Right? So there's no witnesses. There are no witnesses to this.
Yeah, like my grandma used to say, what a coinky dink, spanking of grandmas. I mean, why aren't they there? And, you know, and the fact is no witnesses, but also the fact that she doesn't want them there. And that's when the act occurs. But again, I'm pretty skeptical, obviously, about her defense. They call it imperfect self-defense. It doesn't have to be perfect, but it has to be self-defense nevertheless.
Let's take a listen now. We've got another piece of this 911 call. And again, as you listen to the voices, it's the neighbor. I believe he's going to be a really important witness in all of this. Perhaps for the defense, I think he's very sympathetic to Ashley Benefield. But you're also hearing, you can hear Ashley in the background. Take a listen.
I know.
Okay,
it's not what people think. It's not what people think it is. I know.
Yeah.
It's not what people think it is, Michael. What do you think's going on here? Now he served this country, so he's been in the service, and I don't know. Is it shooting a gun? Is it what is he talking about, and how would that impact the jury?
See, that's the point, Vinny. That's cause for speculation, right? So that type of speculative statement, that type of speculation probably shouldn't be introduced to the jury because it doesn't have the necessary indicia of reliability that's required when you're in a search for the truth in a trial. So I think that's probably why that statement is not going to come in, because he's saying it's not what people think it is, or whatever his personal opinion might be. It is speculative, and it calls for speculation. And so you don't want to put that type of speculation in the jury. You want to take the facts and lead them to the logical conclusion, whether you're on the defense or the prosecution side, and you don't want to invite speculation for the jury. And I think that's probably why that statement's going to be excluded.
Rick, what do you think about the neighbor? I think this is a really important person. It's the closest thing to a witness to what happened, other than Ashley Benefield, who is seeing the aftermath of what happened here.
Right, and he's going to be very important because he sees her immediately after this thing is taking place. He judges how she acts, how she looks. He's going to be a judge of how did she come in, and what did she look like, and were there any injuries. There's a lot of things they can ask him that he's going to be able to provide some insight to. So I think they need to, on both sides, they're going to need to hone him down as to what he actually saw, what he actually knew. And in Florida, as you know, we have discovery depositions, so they've already talked to him. They already know what he's going to testify to, and so they're trying to use him in the way that most accurately portrays the case that they're trying to put down.
I always forget Florida. You have the depositions, you have stand your ground. Like, everybody has testified perhaps multiple times before you get to trial. Let's take a listen to more of the 911 call. And again, this is the neighbor with Ashley Benefield, and then you've got the 911 operator on.
I got to stay on 911. Let's look out this way. Make sure that you don't see her. They're probably still at the park. If I see them, we'll go out and stop them. Okay. Would that be all right, ma'am?
Yeah.
Okay, so they're looking outside for Grandma and the young child to come back. And you hear Ashley Benefield in the background. And what do you think? I mean, that's going to be redacted, so the jury doesn't get to hear that. I think if the jury did hear that, that could potentially help the defense if you hear her actual emotions in the moment.
Well, absolutely. And of course, the evidence rules on this are raised gesti and excited utterance. And there's an issue of reliability when there's this kind of excited, testimony coming in. And like Michael talked about, and of course, 911 calls are exactly that, right? I'm kind of not understanding why there's all these redactions. I mean, in Washington State, it would probably all come in, you know, under the rule of completeness and everything else, just put it out there. But that having been said, that would help the defense. Who in this case made these motions? Some of these from the state, or some from the defense. I know you said, Rick, you pre-litigate a lot in Florida, like we don't out here. So if they had this full motion hearing, because the judge was talking about redactions earlier, and basically saying he's kind of his head swimming, and he kind of wants to get to the nut of the thing and try the case.
Let's take a listen to the last one now. And again, the jury is not going to hear this, but you will.
What's the female's phone number?
I don't know. I have to ask her, and she can tell. I don't know it off.
Can I get her on the phone for a second? I can ask her myself if you need.
Can you talk to her for a minute?
I can.
No. Huh?
I just need her phone. I just need her phone number. I'm not asking her any questions.
All she needs is your phone number.
All right, this is interesting. She didn't give a statement to police. She didn't talk to 911, Michael.
Yeah, I think this is Fifth Amendment privilege, right? I mean, if you consider 911 an extension of law enforcement, I mean, obviously she's not in custody or anything like that, but this is her basically, you know, keeping silent, regardless of the fact that she's, you know, it's not custodial or anything like that. But what you have here is her saying,
it's interesting, right?
I can't talk.
I haven't seen this before, Michael. I have not seen someone not give a statement, not even talk to 911. It's obviously it's an advantage for the defense, Michael, but have you ever seen this before in a self-defense case?
No, Vinny. No, Vinny. In fact, I was in court arguing the other day that my client should get a bond because he was the one who called 911 and talked to them about what happened. So no, I have not, especially in a self-defense case. I've not seen it before because typically in a self-defense case, you're trying to put forward your story as quickly as possible. But here you have someone, and listen, we don't know why she didn't want to talk to 911. I mean, she obviously sounded hysterical. She sounded sort of besides herself. But
she almost sounds like she spoke to Rick before all this happened and knows not to say anything to anyone. We're out of time for tonight, but we're going to continue. We're going to continue our coverage. I look forward to speaking to you guys as this trial continues. Rick King, Ann Bremner, Michael Sterling, thank you so much.